I'm going to briefly, we haven't done this yet. I don't have a lot of time, but I want to briefly cover the errors in the case. I think
Yes,
it's
please
important.
do.
So
I
there's
think so too.
15. Again, we have the 12 key questions, which I don't have time to go through them all. Actually, for the sake of posterity, we'll do it quickly. I think it actually is important. So there's 12 points at issue. In any federal case, you have to list what are the questions you have to have the court, or you want the court to answer. So we've got 12. The first two are jurisdictional. So we're asking, but they're not related to the case. We can't argue. The next three are employer related, right? Can companies write policies granting themselves to write the law, break the law? And then a corollary, can companies write policies granting themselves to break contracts? If such absurd and nullified policies are issued, are they binding anyways? Like, do they stand? Do you have to get a court order to strike them down? Or sorry, the policy is written, it's too late now. Carte blanche. Are contracts in common law ultra vires for e-adjudicators? They claim they are, unless they need to cite them to deny benefits, which is what happened selectively, intentionally. They reverse engineered. No matter what information you gave them, they purposely used the decision tree that resulted in benefits being denied, even if it meant contradicting their own arguments from prior cases, sometimes in the same week. Number 7, what would be an acceptable lawfulness test? In other words, by what standard should policies be deemed legal, contractual, and binding? Number 8, can tribunals violate home statutes by citing case law? Right, this is the oft-repeated question that, well, the policy says. No, like, do statutes govern or do case law? Can they violate the statute because they found a case they can somehow twist to say they can? Number 9, what happens? This is the selective engineering. What happens when they treat like cases differently based on the outcome? When they purposely engineer decisions that contradict each other in order to have a consistent outcome. Number 10, this is the VE memo. Can they use internal and undisclosed information in their cases? Is that reasonable? Vavilov says no.
And Vavilov, if we can just explain, Vavilov is the kind of like the gold standard case law that's used to determine reasonableness.
Yes, so every decade, the Supreme Court chooses what they think is the most effective case in the last year or two of the decade that governed administrative law. So administrative law is specifically tribunals and government agencies appealing decisions of ministers and stuff like that. So every decade they update. Vavilov was the one from 2019, which would be good until 2029. It is binding. It defines the processes and the tests that must be used to have a reasonable decision.
It's like the Oakes test, guys. You guys know the Oakes test, where they need, if they're going to, which there should be no Oakes test, there should be no overriding of your rights, but there's a threshold that needs to be met, a test that needs to be conducted from the Oakes Supreme Court case that says there must be a good enough reason to take away your rights.
So the last two, I'll get into this in a second, but if there is an error in the case law, who gets benefit of doubt? So a decision was made incorrectly by a judge in his obiter. So he was commenting on a separate issue in his case, and that got picked up. He said it's not in the interests of justice to have the public fund employer misconduct. And of course, that was rarely cited until the pandemic, and all of a sudden, been cited well over 100 times, saying it doesn't, even if your employer broke the law, it doesn't matter because the public shouldn't have to fund that. And of course, the EI Act completely refutes that. There is no public funding.
And what they're talking about, and what they're talking about is the public paying for your EI in this case. And we all know that's not true.
And then number 12, related, what happens when case law is wrong for decades? So that's the 12 questions. We're in a statute court. So if we follow their own rules, the statute presides. You cannot use case law to override what is a clear mandate from Parliament or a clear requirement from Parliament.
Yeah, and we all know that's, well, we know that's not what's been happening.
No, so that's what drove me, because I was reading hundreds of cases and seeing how they're holding it the same way. So I decided I want to actually see what does the statute say. So I spent don't know how many, a huge amount of time reading thousands of pages from the Parliamentary Handbook, which we're going to get into tonight, showing how the legislative intent and the legislative history of the EI Act are clear. The fundamental, and in fact, the only factor to consider when determining whether or not you can disqualify or disentitle claimants from EI is whether or not they have just cause. That's it. According to the statute, whether or not they have just cause is the determining factor.
Mm-hmm.
And that's what we're going to be discussing.
This just cause was for both parties, right? Like I remember back in the day, like, because, okay, so EI obviously is when you're employed and you lose your job, and it's supposed to be typically when you get let go, like not a firing because you're an idiot, but because you got let go, or like, and you could be fired, but there could be you could have been fired without cause, or you could have quit with just cause and still collected EI. It wasn't this, you lost your job and it wasn't because of a layoff, now you don't get EI. It wasn't that, because I remember people, friends quitting their job, but they had a valid reason, like bad working conditions or whatever, and they would go to EI and they would apply, they would provide the justification, they would provide the information, and they would still get EI. So it wasn't just one-sided, it was for both sides to have an opportunity to still collect the money that they have paid into their entire lives.
Exactly. And we're going to get into it time depending, but there are hundreds of cases prior to 2020 where just cause analysis was done. It wasn't until these new processes were engineered and templates were intentionally created that bypassed this to abuse the process. It wasn't until that happened that just cause was all of a sudden ultra vires, like outside of the jurisdiction. It was understood. It was widely done. Obviously,
and
the
I
BE
also
memo.
want to Sorry, I also want to address too. I want everyone to also know this. They had hired new people, EI, to make these decision makers, like the low level decision makers. They had hired from, correct me if I'm wrong, they had hired kind of a new batch of people to help with this decision making process.
Yeah, they went on a hiring spree.
Yeah.
When you take people and pay them twice the annual salary, who
Right.
have no understanding how the law works, and you train them and say, this is how it's supposed to be done. Like, what are they supposed to do?
Mm-hmm.
Do they even know that what they're being trained on is unlawful? Or are they just, this is my job, I'm getting a lot of money. Maybe there's other incentives as well that make me,
Bonuses, I'm sure.
yeah.
And everyone's behind a screen. You don't know who they are. You don't get their names. You're lucky if you get to talk to them. Like, just like everything was under the cloak of convid, right? So there was, it's like before, you go in the EI office, you'd see a person, you know their name, and then a lot of things weren't even being signed by names. It was EI officer. I digress for a moment. Sorry.
No, it's good. And we've found, through research that a lot of HR departments at major corporations also had temporary. They had acting people who came in like as headhunters. I forget the word, right? That they brought them in temporarily, gave them temporary authority as an acting director of HR, and then when everything hit the fan, they just, okay, now we'll go back to having someone else. So they intentionally put someone in place who, by the time the lawsuit started, would not be connected to the company anymore.
Yep.
This all started with the BE memo, which I'm going to get to in a second. But the BE memo, one of the worst things it did is it created a new concept called exceptional circumstances. Exceptional circumstances is nowhere in statute, it's nowhere in case law. They just invented something, whole cloth. That,
Just like
in exceptional
convid.
circumstances, we can change the process. And we're not changing it for everybody, we're just going to change it for a specific group of claimants, those who refuse to comply with policies.
So crazy.
So the next problem is rule of law and jurisdiction, and there's 3 subproblems. There's rule of law and jurisdiction. In this section, we're dealing with their whole argument that, hey, things are not not within our jurisdiction. Well, no, if you actually apply the rule of law to the statute itself, it's clear this is within your, it's not only within your bounds, you're required to do it. Next is private law and common law. That's how they abuse things like examining contracts and applying KVP, which again, were widely documented and done before the pandemic. And all of a sudden now we don't have to do those things. Then they constructed a test that had 2 logic errors in it and made that test templatized as the process to follow. So if you didn't understand what they were doing, your flowchart is going to end up in a situation where it is against the test to examine whether or not the employer broke the law. So again, if you don't understand the law and you're just operating off your templates with the BE memo, then you're going to follow it. And guess what? You're going to use this test, which has logic errors, and ends up 100% of the time denying people EI, saying, yeah, we don't have the power to examine whether or not the employer broke the law. Problem number 3 is case law. We dealt with that somewhat before. I think that was in the first one, but they proof texted. They pulled out of context. They found 5 historical cases that were decades old where people violated their contracts. And in those cases, the judge said, you know what, you broke your contract. We're not going to investigate what the employer did. And they pulled out that part saying in misconduct, don't investigate the employer. They templatized it and just made it the defined process. And there's a difference. In each of those 5 cases they cited, the claimant admitted they broke their contract. So of course, why are we going to investigate what the employer did? They've twisted that into if the employer claims or alleges misconduct, we don't have to investigate what the employer did. So they're twisting case law to abuse the process, right? It's abusive process. When a statute or something is required and you find a way to avoid what is a required process, that's abusive process, and you can have your case run out of court for it. They ignored key facts in the record. CEIC, the EI Commission, actually changed facts, which is also sanctionable, just like abusive process, where they, when their decisions were being sent to the tribunal for review as an independent investigation, they said, oh, we made a clerical error. Our decisions that we made in the past were actually mistyped, and we're going to change our whole decision and just say it's a clerical error. Again, that's sanctionable.
Whoopsies.
Yep, they selectively applied the law that had to do with templates. The BE memo, that's really important, where Vavilov is clear that you cannot make decisions on the basis of internal evidence that is not available to both parties in the court. And yet they did. They abused a process whereby the minister has the ability with the director of an agency to create internal policies, but it's supposed to be public. And they created an internal memo that completely changed well-established definitions, legal tests, and adjudicated processes, well, covering their butts. They said this process or this policy is not linked to any legislative or regulatory amendments, and yet it had force of policy. It was given to people in training sessions, but it was withheld from the public. Then there's problem number 6, the precedent error WEI. That's specifically, just for time's sake, that's where they found old cases where judges were opining that it's not fair that the Canadian taxpayer should have to subsidize EI for employers who break the law. And of course, that is not what happens. But again, 160 claimants at the time I did this were given that exact reason to deny them EI. And it's not true. If you read the EI statute, since 1990, there has been no taxpayer funding of EI.
And this case law was, that case law was post 1990, right?
Yes. Yeah, the first one was 2007. It was repeated twice more, I think 2010 and 2013 or something. Like it was only mentioned 3 times.
This is where, sorry, go ahead.
And the second 2 citations were citing the first one. So again, the judge was not making it part of his decision. It was obiter dicta, right? Other words.
Yes.
Which is where a judge is explaining his philosophy, but it's not core to the decision.
Right. And I just want to, like, just talking about, you know, some of the issues with the judicial system and justice. And I feel like, you know, because one of the things, like, if you're convicted of a crime or whatever, you cannot appeal based solely on a judge's decision. So you would have to find an error in law. But and this is not part of the decision, but I feel like there's a bit of a miss in that, because I've seen a lot of cases where it's like, this is not true, much like this. And there should be some recourse with the Attorney General or with the Justice Minister, whoever is responsible, to say, look, this needs to be corrected. Because if if we're going to sit under this frame of common law, which again, I'm starting to really think that this is a problem. I mean, statute's a problem too, right? But if we're going to use this common law system and a framework, then we must be able to correct when a judge has made an error, whether or not it's part of the actual decision or not. It's now being used against us when it's incorrect.
Yeah, and that's what we're doing, because generally speaking, the way to challenge a minister of decision, you have to have standing. So you
Mm-hmm.
can't just file a cause of action in the
No,
court. They would say the
no.
proper way to do it is what we're doing. You have to raise those arguments in the case. And we've done that. This is the only case where we've raised these arguments in the case, and it's been ignored all the way along. That's why public awareness is so important, because we
Yes,
need to show the court
absolutely.
we know what happened, and there is no other way to fix it. The only way to fix it is to challenge the decision by someone who's affected. We're the only case that's done that.
Yep.
So if we get courageous judges who will comment, I mean, everybody's ignored our arguments, even if they don't agree with them. The fact that they have to explain how they're not a problem means they're going to have to write a lot of words justifying how it's okay for everyone to break the law and engineer all kinds of decisions that are clearly unfair and violating precedent.
Mm-hmm.
And that's a record. And then problem number 7 is templates. Back in 2015, they restructured the tribunal and they made a case management tool that has templates. And we'll get into a couple of them tonight if time permits. But essentially, some of them are long, some of them are short, but they're pre-written sets of paragraphs with corresponding footnotes and case citations that get inserted into the decision. And it's explaining it for them, and then they have to fill in the blanks around the template. Of course, that egregious violation of procedural fairness. You're supposed to deal with my decision, right? It's not right that you can just turn around and, well, I'll just take pieces of this case, pieces of that case, pieces of that case, stick them together and then fill in the blanks and call it your decision. I mean, their training materials call it structural backbones that set out the legal test in advance. That's what they call it. And they're told you have to do them. So what happens when you have legally conflicting templates? So they can pick and choose the ones they want that allow them to deny EI. They'll just pick and choose the template that gets the decision they want, which again is totally a violation. Reverse engineering decision outcomes is a violation of procedural fairness and Vavilov. Just a quick comment on the root cause. Part of the problem is that this was engineered. There's a diffusion of responsibility. Any one error on their own probably wouldn't stand. But when you have processes that are gamed from the beginning, right? So you bring in people who don't have legal backgrounds to make, head chopping decisions, and they don't have any experience except what you tell them. And then you give them internal memos that tell them this is what they're supposed to do. In training, on the threat of insubordination if you don't, and then you review that, it goes to the EI commission, and they can turn around and, yeah, well, we're going to just change our mind. Yes, we said something before. Yes, it was the primary decision, but you know what? It was just a clerical error. We're going to change our stance. And the tribunal accepts it. And the tribunal is working with templates that set out the tests and processes in advance, right? That has tests that have intentional logic errors built into them. And these templates are also misciting case law to abuse the process, to change a required process in order to avoid examining whether or not employers broke the law. You put all that stuff together, and you can see how it lasted as long as it did. And that's what we're calling out. Most of the
Yeah.
people genuinely didn't know what they were doing. Some might have had a conscience, right? The fact that 20% of the tribunal members left their position, many with time left on their appointment between late 21 and mid 22. I think that's telling.
Yes. How many?
20%. just over
That's
20%.
that is an absolutely insane number. Imagine if you had 20% attrition, like as an employer, you'd be, what the hell's going on? And they, I bet you any money, Matthew, they were like, we know we're going to have some attrition. Let's just have some people in the wings ready to go. Because how fast were they replaced?
Fairly quickly. Again, the tribunal went on a appointment spree too. So tribunal members are appointed by the governor general. And they lost 20%, but then they added roughly 40%.
Oh, yeah.
Because
They
there were
were
so many
busy.
cases. They
Yeah,
got
they were
slammed.
busy. Yeah.
And we talked about it, but didn't have the number last time. Generally speaking, about 60%, so 3 and 5 represent themselves. They have an annual report.
Yep.
In 2022, over 90%, they had an increase of 214%. So they more than doubled their caseload during that time period.
That is just
And in that
nuts.
time, yeah. And the fact that 90% represented themselves, I think it was so damning. I can't prove the motive, but in 2022, they actually pulled that section out of their annual report and put it in a footnote. Generally speaking, they have charts and graphs at the top to explain it. And in 2022 only, it's the only time since 2016, they pulled that stat out of the headline of the report and buried it in a footnote. And then in 2024 and 5, they went back to publishing the stats because it was more acceptable.
It's almost like when they stopped reporting the flu during COVID.
Oh, isn't that curious?
Right?
And the symptoms
And what
are
do
the
you
same.
know? It matched the same numbers. Yeah. Oh, this
All
is
right.
very telling. And Matthew, I also like, you touched on it, and there are a lot of people who let's be honest, fucked up people's lives. And they thought what they were doing was right because they came into this job, they came in off the street, they had no experience, no background. They were told, here it is. And they're like, you know what, guys? Like, excuse me, Miss Sally Smith. I know you worked at this company for 30 years, but it says right here, Sally, that you can't do this and you're not getting any money. And I know a lot of people dealing with these individuals, they were rude, they were not nice, they were all kinds of things. And, giving people the benefit of the doubt and knowing how they were hired and what happened, they're still doing it. West Side says, well, it's kind of the name of the game. Well, they're empowered to do it, right? And in
Yeah.
their mind, based on what they were told, you're not entitled. Why are you bothering me? Go away. You should know. You should have known, right?
Yeah.
So,
And of course, you have mass brainwashing, right? You have a seditious media that's intentionally lying and spreading hate so that these people are thinking, well, these people are rebels, they're grandma killers. They don't
yeah. Oh,
qualify
yeah.
for
Yeah.
EI.
Right. One life too many. One life is one life too many. Meanwhile, I wonder how many people committed suicide for not getting their EI or ended up like, how many people, the damage that was done to the people that lost everything, we will never
Yeah.
know. And people, it's just sad. It's just sad all around.
Uh, and we can't
Yeah.
get accurate stats, but there's been a significant
No.
increase in people applying for MAID. We know
Oh,
specific stories of people who are severely vaccine injured. They were not helped.
absolutely.
They
No,
were
as a matter
pressured
of,
into killing themselves.
yeah, oh yeah, for sure. Oh yeah, they were, and then Maid's the new it. Yep. Mitchell says right now, when you talk to EI, you can't even get someone you can understand on the phone. Of course.
Yeah, that's
Yeah.
what I meant by incentives.
Yeah.
Because you're not just dealing with people who have no legal training, who
Uh-huh.
have double paying jobs. These are people who, if they're trying to obtain citizenship, if they lose their job, guess what? They're going back to India or Pakistan or whatever country they came from.
Wherever. Yeah. Yeah.
So I mean, how do you fight that incentive?
Yeah. Yep. And that's like fight you to the death. That's like where I'll fight you to the death. I'm not, I want to stay here, especially when they're getting these government jobs. It's huge.
Mhm.
like it like you can't, like, it's almost impossible to articulate what you've uncovered. And it's massive.
Yeah.
It's
$12.9
massive.
billion,
So
hundreds of thousands of people.
how much? Oh yeah, how much?
$12.9 billion is the estimate. That was Lex Acker. He's a financial fraud investigator, and he pulled public data on EI claims and on pension. He looked at the net change in pension contributions and compared that to EI to show how many people that stopped paying their pension left because of an EI claim and never went back to paying, right? And he found if those people multiplied by the EI you should get is $12.9 billion, which is more than 50% of the entire operating budget for EI. That's why they couldn't give it to us.
Oh
That's why they
yeah,
had to construct,
they
they had to
knew.
engineer this massive system.
Yeah, and they knew, like, yeah, like, I mean, you know, who knows how long this was planned, but we know it's been planned for a long. Poutine on Rumble says my blood pressure went up. Yeah, it's
Good.
really,
I mean, it's not good, but
yeah, no, we need to get fired up. We need to get fired up over this. Guys, share this with anybody that you know that has that was had their EI denied.
yeah.
And if you know any groups, I think it's really important to share this with them. And we got to get the word out because this is like,
And please comment. The Substack is set up for that reason. We want to document this. It's one
yeah,
thing to say you're displeased with what happened to us. It's something very different if we can show there's a record of hundreds of people who are not only sending letters to the courts and parliament, but they're also saying, hey, me too. So I would love to have a very interactive dialogue on the
yeah,
Substack where people comment, share their stories. If you want, you can publish. Everything that we're relying on is published. So if you want to read through the answers are there. If you want to read through things like the BE memo, they're all there. I've got hundreds and hundreds of examples of templates being used and abused.
yeah. Okay, Matthew. Thank you so much. And like, guys, all of us need to work together to share this information, share it with the groups that you know. And really, this is all about if Matthew wins, guys, this is fucking huge, like huge, huge. So I gotta sign off because my brain
Yep,
is shutting down. This was a lot of great information. Thank you so much for taking the time out. Thank you for all the work. Just thank you, Matthew. Like,
you're welcome.
genuine thank you for what I believe you're going to accomplish for all Canadians.